Okay. Good afternoon, everybody. Thank you for coming and thank you for watching live on the webinar. For those that don't know me, my name is Blake Safford. I'm the Director of Retail Business Development with NewView Trust. I've been here going on 6 months now, so I'd like to thank everybody for coming. By show of hands, I always like to get an idea on how many of you are clients of NewView and how many are new to NewView. So who's a NewView client? Okay, awesome. And then the rest of you are hopefully prospective NewView clients, and you've heard about our event from, heard a lot from Candace and CFRI, so I'd like to welcome you and thank you for coming. Today's a special day because we do have a unique topic today on land trust basics, who's going to be hosted by Andrea. And before we get into that, I'm just going to do a brief intro on NewView Trust and what a self-directed IRA is, and then we'll hand it over to Andrea. Okay, so before we begin, I'm just going to read a little disclaimer. NewView IRA is not a fiduciary and only provides services to self-directed accounts that are non-discretionary and or administrative in nature. The account holder or his or her authorized representative must direct all investment transactions and choose the investments for the account. NewView IRA has no responsibility or involvement in selecting or evaluating any investment. Nothing contained herein shall be construed as investment, legal, tax, or financial advice, or as a guarantee, endorsement, or certification of any investments. So what is a self-directed IRA? We get a lot of inquiries about, is a self-directed IRA a type of plan? And it's not. It's no different than any of the traditional retirement accounts that are available to you at traditional financial institutions like Fidelity or Charles Schwab or Vanguard. Simply, a self-directed IRA is an IRA where the owner directs all investments themselves. So there's no one that's managing the account. A self-directed IRA account holder chooses their investments. There's no legal distinction between a self-directed IRA and any other IRA except for the fact that there's more choices within a self-directed IRA. A self-directed IRA allows for alternative investments not offered by traditional custodians. Traditional custodians, you know, like I mentioned, Fidelity, Charles Schwab, Vanguard, they're going to have the more traditional investment options offered through the stock market, like bonds, stocks, mutual funds, that sort of thing. But where NewView fits in is we are a custodian for people who want alternatives. And in order to purchase alternatives, you need a custodian like NewView. So that's where we fit in. So what are the benefits of self-directed IRAs, and why would you even want to participate? So number one, a self-directed IRA offers diversification. For the clients that don't want to put all their eggs in one basket and they want diversification, they need a custodian like NewView who will hold alternative assets such as real estate, private placements, private stock. I could go on, but anything that is outside of the stock market would be considered an alternative asset. The other major benefit with a self-directed IRA or using your self-directed IRA in an investment opportunity is the tax savings. The tax benefits, you can either avoid the taxes by paying the taxes up front or defer the taxes and pay the taxes when you are qualified to take distributions from the account. So the benefit of that, if you're saving on taxes, you're unlocking more capital, so you're able to take advantage of more investment opportunities and giving yourself more options. And then last but not least, one of the major benefits of a self-directed IRA is it allows you to invest in what you know and understand best, or what you are interested in. A lot of people come to us because they're learning about investing in to fix and flips or wholesaling, tax liens, tax deeds, private placements. All of that can be achieved through a self-directed IRA because you're allowed to have those choices. So where does NewView Trust fit in? We are a custodian for self-directed IRAs. We house over $1.2 billion in client assets currently. And our role is to provide all the administrative and record keeping of the IRA account holder. So NewView IRA processes all the transactions. We do all the record keeping. We provide all the necessary forms in order to execute on these transactions for you. NewView IRA, what makes us unique is we're simple, available, and responsive. And we're here to build a relationship with you. You know, some of the other bigger custodians out there might not be able to offer that. And we pride ourselves on being able to offer that relationship with you, which is what makes us unique. Okay, so this is a nice example of comparing us to the traditional brokerage houses like a Fidelity or a Charles Schwab, and really shows the difference in earnings made inside of an IRA. So if you look at this is a graph. 35% of an average mutual fund is paid in management fees and commissions, whereas a self-directed IRA, you're not charged on the earnings inside that account because we don't charge commissions based on whatever you grow that account to be, which is probably why we have a lot smaller building than a Fidelity or a Charles Schwab, but that's the primary difference, is the commissions and earnings inside of an IRA. And this is an example of what it would look like if you did have an 8% annual return with NewView. That commission percentage doesn't get touched at all. Okay. So why don't advisors recommend self-directed IRAs? Number one, they require a custodian like NewView. Number two, it's more of a one-off basis, and a lot of the transactions are not as easy to complete like a stock or a bond or a mutual fund can be a lot easier to process. So that's why when it comes to buying real estate, processing private placement transactions, those types of investments are better suited with an alternative asset custodian like NewView. But the biggest reason is they don't earn commissions. So that's the primary reason why they don't recommend self-directed IRAs. So this is a great illustration on the tax benefits of a self-directed IRA, or making your investments inside of an IRA. If you look at this, this is the example of taking $1 and doubling it 20 times. The first example is doubling $1 20 times at a taxable percentage of 25%, which at the end of the day, you're left with $72,570, which I think we'd all agree is a nice investment strategy, whatever it is that you're doing. But I want to take that example and look at what happens when you do it inside of an IRA with the tax benefits. If you take that $1 and you double it 20 times, you're left at the end of the day with over $1 million. So why is that a benefit to you? Obviously, it's more money, it's more capital. It enables you to invest in a wider range of choices. So that's what we're here to help you do. So what are the different types of accounts that you can self-direct an IRA? I'll start with the traditional. This is where home of most 401ks go to. So if you have a pre-tax 401k where you have made contributions that are tax deferred, this is where you would roll over a 401k that's pre-tax. I touched on the Roth IRA a little bit. The difference between the traditional and the Roth is when you're paying the taxes. So with a Roth IRA, you're paying the taxes up front rather than paying the taxes when you take the distributions out. We also offer the SEP IRA and the Simple IRA. The SEP IRA stands for employee pension, which is an IRA plan for business owners. As you can see, it allows for a higher contribution amount up to $55,000. And then the Simple is an employee match program, kind of similar to a 401k. The only difference is it's up to 3% that the employees can contribute into the account. And then the last three we have are the health savings account, which is a health savings account for individuals with high deductible healthcare plans. This is a great account because it's the only account other than the Roth that allows you to grow your earnings tax-free. And then when you take those distributions out for qualified medical expenses, you're not taxed on those as well. Educational savings account. This is similar to the health savings account where the distributions are taken out and can be used towards a qualified educational expense. So it's very similar to the health savings account. The only difference is really the contribution limits. You're allowed to contribute up to $2,000 annually into the educational account. And then last but not least is the solo 401k plan. This is probably one of our most popular plans as of late. This is for individual business owners who want a higher contribution amount. The two major benefits, I won't get too deep into this plan, but the major benefits with the solo 401k is it does allow you to take a 50% loan from the plan. And then if you are investing into something where the plan is taking on debt, it eliminates the fact that you're subject to UDFI. So you're not subject to UDFI, which stands for unrelated debt financed income tax. And then this is the last slide before I'm going to turn it over to Andrea, but this is a slide that shows what your options are with a self-directed IRA. Like I said, anything outside of the stock market, stocks, bonds, mutual funds, these are the choices that you have inside of the account. So anything from real estate, mortgage and notes, private stock, partnerships is really popular, especially amongst clients here at NewView, precious metals, LLCs, and then debentures. And there's plenty of other things that we see, but those are probably the most common choices that we see here with our clients. So with that said, I'm going to turn it over to Andrea, who's going to talk to you about land trust basics.
Okay. I think I'm on. I just flipped the switch. So, okay, well, thank you all thank you to NewView for having me. It's a pleasure to be here to speak to you about land trust. I am a partner in and manager of Commonwealth Trust Services. So what we do is we are a corporate trustee for people that want to place their properties into trust. We serve as the trustee for those properties. As Blake just said, my name is Andrea. I'm Andrea Ehlert-Hosch. I am an attorney, a real estate investor, a realtor. I've been an attorney since 1988. And for a good portion of that, I actually considered myself a real estate attorney. I practiced foreclosure law, but I had never heard about land trusts until I became active as an investor and I joined a coaching program and learned about the benefits of a trust, of a land trust. I've heard a lot about other kinds of trusts. I always like to bring that up because when you're doing this business and obviously doing things to build your accounts, you're going to need a team to do that effectively. And you want to make sure that the team members that you have, your attorneys, your accountants, your title companies, your trust company here, your account holders, trustee company like NewView is going to understand what a land trust is, because I would say probably 90% of attorneys don't even know they exist. So why do I need a land trust? Well, why are you self-directing or why are you in the business of real estate? We're trying to purchase real estate. We're trying to grow our wealth through real estate ownership. And as you grow your wealth, you want to protect that wealth. Oops. Okay. I think my little cursor is not working anymore. There we go. What is your why? So we're building our wealth for certain, for certain goals. Our whys, I know if you're here at this seminar, in particular, you're online today, you are interested in building your accounts and understanding how you can do that in a safe manner. So retirement is a big consideration. Blake just went over the different accounts that they offer here. Healthcare, obviously, we want to plan for the future. You want to grow that account, college education. providing that for loved ones of yours that you're building those accounts. And you can partner in those different accounts in real estate through using a land trust, and in notes and mortgages. And so those are all great things that you want to be able to understand how to protect as you grow those accounts, because our ultimate goal is financial freedom. We want to get to the point where you can use that account money, you've grown it in a safe way, and it's there for you to move on and enjoy your life. So how many of you own rental properties outside your IRA? Yeah. Okay. And how about inside? Okay, great. So you're building a portfolio. You're in the business of growing your account that way, or growing your business as a real estate investor. That is becoming the vehicle that you use. How many people flip or purchase to renovate? Okay. And I'm sure there's people online doing that as well. So you want to do that and repeat, right? You want to grow your income when you do that. So you're building your accounts by loaning, or some of you may be lenders who's building their accounts by loaning to people who are buying holds and doing fix and flips. So what do all of these fix and flips and buy and holds and maybe other real estate interests like notes and mortgage, what do they all have in common if they belong to you? They're going to have your name. The owner's name is going to appear on public record. So that's one of the biggest benefits that we're going to talk about with the land trust, is how to avoid that. Your bank account is private, right? If you're growing your wealth through putting it in your savings account, can anybody search Bank of America and see what you own? No. So shouldn't your real estate holdings be private as well? Your retirement account here at Newview is private. If you have an Edward Schwab account or some of the accounts that Blake mentioned, those are all private. So we're going to talk about how to keep your biggest assets that you're working on accumulating to your vehicle to wealth private as well. Now, I've often gotten some pushback from title companies and other people that don't understand what a land trust is. And they say, well, that's not legal. Well, in Florida, we're very lucky because this unique tool called a land trust, which is actually available to be used because it's a trust, an inter vivos trust. It's available to be used in about 49 of our 50 states, but in only 6 states is it statutory. So in Florida, it's actually on the books as law. It's going to help you own and transfer real estate in a more effective way for your business. And it's more effective because you can't search it and you can't connect it to yourself. It's set out in Florida Statute 689.071 and 689.073 for those of you that want to Google that and read through it. It's really not that long. It's actually pretty short and pretty easily understandable. So how it works is that the property ownership actually vests in the trustee for the benefit of the beneficiary. So that's how it stays private, is the owner on public record is the trustee, but the beneficiary is going to retain complete power of direction over that land trust and directs the actions of the trustee. Now, a lot of times when I'm first talking about this to people that don't understand how it works, they're like, wait a second, I don't really want to deed my property to somebody else. Where is my protection? Well, as I said, in Florida, it's very clear. It's statutory. It takes 2 documents to accomplish this. It takes a warranty deed to trustee, so that property, whether you're purchasing it into a trust or you yourself are deeding it to trust, it'll be signed by the grantor and deeded to the trustee. And the trustee on public record is going to have all those powers to sell, assign, transfer, convey that property. That's them having all of those trust powers is what enables you to keep your privacy. Because there's a lot of other trusts out there that are not land trusts where, sometimes people put property in those trusts. Now they're usually family type of trusts and they have the family name associated with them. In those types of trusts, typically the beneficiaries are going to have to sign off on a transfer or something. And this they don't. So your name is not connected to that even after you sell the property. But the second document is super important. That's the land trust agreement. That's the contract, if you will, between the trustee and the beneficiary. That's what gives all the rights and powers back to the beneficiary to direct that. And it's a contract, obviously can be sued upon. It is based on statute. So who is the beneficiary? The beneficiary is the real owner of the property. They have the power to direct the trustee. They have all the rights and responsibilities of the property. The land trust trustee should not, we certainly don't, manage your property. We're not going to accept funds, rental checks, anything like that. All of that is up to you. You're going to collect the rents, or you're going to tell us what manager you want to collect the rents, and we're going to sign a management agreement with them. You're going to pay the expenses, the upkeep, or the expenses for the renovation. You're going to pay the taxes, make the profits, the losses, and get the depreciation. Now, this is really important. I'd like to point out here that a land trust is invisible as far as the IRS is concerned. It's not like those other trusts that have an EIN number or a TIN number. This is a trust that is transparent. So anything that's put into that trust, all the profits and avails are going to flow through to the underlying beneficiary and be taxed however that beneficiary is taxed. So if an LLC, it's going to be taxed that way. If it's individual, it's going to go on your individual taxes. If it's an account here at NewView, then there's probably not going to be any tax consequences unless, you know, the UDFI or something is involved. Now, who can be a beneficiary? This is the really cool part, is that any individual or group of individuals, any partnership or limited partnership, any irrevocable trust, trustee, out-of-state trust company. I always like to stop there and say that if you have an estate planning trust set up, or you're going to set one up in the future, and you want the properties that you have now in your land trusts to flow into those trusts, those types of trust upon your demise, then they can actually be your successor beneficiary and pass through to those trusts without probate. Any LLC or corporation, any self-directed IRA, HSA, 401k plan, individual K plan, and I think we left out the ESA when I was looking at Blake's list. But basically anything with any taxable entity or person can be a beneficiary, and any IRA, HSA, 401k, any of those types of things. Of course, their tax ID number is the NewView tax ID number. Now, who is the trustee? The trustee is the title owner, the owner of record. They have the public powers to transfer the property, but as I've already said, through the land trust agreement, their only task is administrative. Anything substantive that you need us to do as the title owner, because there are sometimes substantive things that a title owner has to do, right? We have to sign a notice of commencement, a listing agreement. You would direct us as a corporate trustee. Of course, we're very careful about making sure that we dot all of our I's, cross all of our T's. But if you're using another trustee, you know, they would want to, and you would want to communicate everything in a written form. So it's all very clear what you're asking them to do. With, you know, listing agreements and things like that, a purchase and sale contract, our clients email those to us with a line asking us to execute those things. Sometimes they give us a request and we require a written formal direction, depending on what the action is. Signing of a closing packet, they would of course review that closing packet and then let us know that, yes, I've approved that and please sign that, either when they're purchasing or they're selling. So we're not going to do any of these things on our own. What are the benefits? Now, this is a case that came out of Georgia last summer. This was a default judgment, $4.2 million against a landlord owned, I think it was an eight-unit rooming house or something, in a pit bull attack. Now, this is not that landlord. This is the happy attorney that represented the claimant. But what I love about this is this line here, that attorney Joshua Davis said he's under no illusion that the property owner, Jonathan Hart, who never responded to the lawsuit that was only seeking $60,000. He defaulted. That was not smart on his part, but that was all it was seeking. But he has no doubt that he can cover that hefty judgment. In addition to the rooming house, Hart apparently holds interest in multiple properties that Davis intends to go after. Now, do you think Davis, the attorney, knew about those properties when that claimant came in before he took that case? Of course. And that's why all of a sudden what was a $60,000 claim is now a $4.2 million judgment. So that is The biggest benefit that you're going to find in using a land trust is keeping your privacy and removing the element of being a target. So as we know, in this litigious society, when people go in to an attorney, first of all, you know, most of us here, it look like, have rental properties. You know, things can happen on a rental property. Sometimes you get somebody disgruntled. A lot of times it's not much of anything. And they'll go into an attorney, and if an attorney finds out that the landlord is somebody that owns a lot, even though that case doesn't amount to something, they know they can make that person's life miserable by filing suit, and it's probably going to get some kind of a settlement. So the cool thing about a land trust is when they look up that property and they see, oh, this property is held in trust. I have no idea who the beneficiary is. I don't know if they own 1 property, 2 properties, 10 properties, if those properties are all leveraged. We just don't know. So your risk really drops. There's no public record. Here's what it looks like with our properties. This is Volusia County, an example. So all of that pops up for all these parcel ID numbers. There's no way to identify a beneficiary, just the title owner. The next great benefit is that liens and judgments do not attach between the beneficiary and that property that they hold in trust. In other words, as you're building your accounts and building your business outside of any retirement accounts, life is also happening. You have teenagers that get driver's licenses. You have a lot of things going on in your life that can cause liabilities and accidents and those kinds of things. And if you get sued personally and there's a judgment against you, it's not going to attach to the property. If the trustee, for some reason, gets sued, that's not going to attach to the property. And if you have multiple properties and you put them each in separate trusts, which is what we recommend, then something that's going on in one property, a code lien violation, is not going to affect the other property. I know we've had clients that have, you know, 2 or 3 or 4 properties in their LLC. They don't have them in separate ones or separate trusts. And all of a sudden they're trying to sell one, you know, they got this renovation, they got it under contract, they're ready to sell it, and there's a code lien issue on one of their others. Sometimes those are not easy or expedient to fix. So that can hold up the sale on the property when they're titled like. So we recommend that the properties in trust be titled separately. And that's really easy to do. Typically, most of our, I would say 99% of our clients just use the property address, the 123 Main Street Land Trust, the 456 Orange Street Land Trust. So they're all unique in the fact that no code lien is going to come against all of those together. Just one, it makes them individual, but they're not so unique that they make people realize, well, this is probably the same beneficiary. If it's the Orange Street 1 and the Orange Street 2 and the Orange Street 3, you know, you don't want to do that type of naming because that could be a clue that they're similar or the same beneficiaries. Ease of partnerships is another great thing. Taking over payments subject to, I'm going to talk about that a little bit more in depth in a minute. But that is sometimes, it's actually very efficiently accomplished in a land trust. Avoidance of probate, I just touched on a minute ago, and secure joint ventures. A lot of people here are lenders, probably. I think we just talked about that a minute ago. Somebody raised their hand at the back. But even if you're, you know, not just a lender, you want to have a little piece of the action. Say your NewView account's going to be 20% of 20% ownership of a property that's going to be renovated. You're really not going to have that much to do with it, but you like to take advantage of getting 20% of the profit and you're going to loan some money. You don't necessarily want to have that on the deed, that your NewView account is 20%. I know we've had properties that are being held by 5 or 6 beneficiaries. Sometimes one time it was 3 NewView accounts and 2 outside beneficiaries that were holding their portion in their LLC. So that looks really, really messy on a deed. You know, 23% is owned by this one and 24% by that one. So this way it can be clean, it can be private, and you can put into place some beneficiaries agreements that outline the rights and responsibilities, and that's all done right within the trust. Now, keeping your purchase price private is also, I'm going to talk about this in conjunction with a subject to deal. I know there's a lot of investors that purchase properties by taking over the underlying mortgage payments. And the way to do that really effectively so that the bank does not know that the control of the property is actually changing from the mortgage holder is for the seller to place that in trust. I would say probably all mortgages these days, even investor mortgages, have a clause in there that says that if the property is sold or transferred, etc., they can call the loan due. It's the acceleration clause. However, that in Florida, we have well, not in Florida, it's an exception to the Garner-St. Germain Act, Depository Act, and that is that you can place your own property into trust for estate planning purposes. So that way, the bank, when the mortgage holding bank, when they see that a property's been placed in trust, it's not so much of a red flag. So the way to do this is the property gets placed in trust by the seller, and then the seller signs an unrecorded assignment to transferring the property to the beneficiary purchaser. So that way, the seller actually becomes the initial beneficiary, and then the next purchaser is the second beneficiary that's going to hold the property. So the property has changed control. And when properties change control, then doc stamps have to be paid. Now, as we know, when the county is just like a receiver for the doc stamps. They're going to send them to the Department of Revenue. But when the county receives the doc stamps, what do? They extrapolate back and they put the purchase price based on what doc stamps were submitted. So then your purchase price is public. With this unrecorded assignment that I was just talking about, when that gets signed, then the doc stamps can go to the Department of Revenue in Tallahassee with a certain form to make sure that those doc stamps are not recorded at the county level. So the seller is going to place the property into trust with the seller as the initial beneficiary. The seller is going to assign their interest to you or to that owner, and then the recorded deed gets recorded at the county level with the minimum doc stamps because it was just the seller placing it in trust, and the other doc stamps for the change of control purchase are going to go to the Department of Revenue and be kept private. Now, this is an example. I don't know how well you can see that slide, but this was one of, actually it was a partnership of investors who had this seller. She had inherited this property. She placed this property into trust. Now, this particular one was not a subject to, it was a cash deal, but it was still really important to have that property placed into trust because the investors knew it was going to be a quick flip. So they didn't want to show like a $90,000 purchase price and then a $180,000 sale price in about 3 months. So that's another advantage of having the seller place the property into trust. Now, so that was recorded as a $100 transfer because the real doc stamps, the total doc stamps on the assignment went to the Department of Revenue. Now, the ways to get your property into trust. There's 3 ways to deed your property into trust. I know if some of you are sitting here today or online and you're thinking, oh, I really need to put some of my own properties into trust, that can easily be done. You simply deed the property to the trustee, and then of course you had the land trust agreement, but that does not require a contract. That, in fact, at our office, it's simply, you go online and you indicate what you want to do. You say that I want to place one of my own properties in trust, give us all the information, and that's done in a matter of days, just like really less than a couple of days. And then you come into our office, you sign as grantor, deeding it into trust, and then we actually take care of the recording. There's no doc stamps on that because you're just placing your own property into trust. The other couple of ways to do that is to purchase your property into trust. And that way, if you don't have a relationship with the seller, it's not important to you, say it's rental property, you're not going to buy and hold it for a long time, you don't care about hiding the sales price, the seller, you're not going to talk to them about placing it into trust, then you would simply have the trust as the purchaser, and the property would be purchased directly into trust. This one is written Commonwealth Trust Services, LLC, as trustee of the name of your land trust. So you'd need your trustee's name, the name of the land trust as the purchaser. And then your ownership of that property is never on public record. Now, when you place your own properties into trust, you are still on public record as the prior owner. But when you go to the property appraisers' websites, at least in Florida, you can't search by prior owner. You just search by current owner. So no one would be able to search your name and find prior properties that you owned. Even if they did come across the fact that you'd owned a prior property, they'd have no way of knowing if you were the beneficiary of that land trust that said at one point you deeded it to a trust. So you can't, if for some reason you are not sure at the time you're entering the contract, or you need to sign it right then, the seller doesn't understand why you'd put somebody else's name on it. So you want to just purchase it in your name or your business's name. And then this is the FAR bar. So this is the additional terms in the FAR bar. But every contract that most people use are going to have some additional lines that you want to write in, terms specific to your deal. So that's the place that you write in: for the purposes of closing this transaction, this property may be placed or purchased into a land trust. And if neither one of those things are done, you simply do an addendum to your contract or you assign it to the trust. So it's very easy to purchase your property into trust. Now, financing and operating your property in a land trust, protections for lenders. I know that a lot of you here with accounts are wanting to lend small, maybe large amounts of money, and you want to know, how is this going to help me? First of all, you want to make sure that your borrower places the property that you're lending on into trust, because that's going to give you some benefits that we're going to talk about in just a minute. But another thing is personal guarantees. You're going to make sure that that purchaser, even if they're purchasing it in their LLC as the beneficiary, that they're signing a personal guarantee. And that's important because when they place the property into trust, the advantage for them is that the trustee is going to be signing the note and the mortgage. Now, typically, the borrower also signs the note. That's not recorded, so that's not going to expose them. But the mortgage is going to go on public record with only the trustee's name on it. So you'd want to have that personal guarantee. Hazard insurance is always important. When I was talking about having a team to help you in this business or help you advance your accounts, you want to make sure that having a good insurance provider who understands land trusts and can get those trusts insured. I've had so many people call me and say, I can't, my insurance company won't insure a land trust. So I give them the name of probably somebody that 80% of our clients work with, and they do insure land trusts. So that's very important, because as trustee, we're going to do everything we can, and we're going to certainly protect your privacy through the land trust documents and the relationship we have with you. As we build our relationship, there's other things that we can help you with. But one thing we're not going to help you with is rebuilding your house if it burns down. So you need to have that hazard insurance in place. Also, the lender would want to make sure that there's a title policy in place, that when this person that is borrowing money from them, when they purchase that property, whether they're lending at closing or later, that they have a title policy that's insured. And they might also want a lender's policy too. Now, a directorship is something that's a tool that we can use within the trust. It is optional. But we have had times when a lender is lending like 100% of the deal, and he's not going to be a part of the ownership, but he wants to have control over this. Maybe it's a newer investor and he's kind of being a mentor. So he may be named the director of the trust, even though he's not the beneficiary. Or you might, like that deal that I was talking about that had 5 entities in it. You know, it's cumbersome when all 5 entities have to send us emails or have to sign off on every direction for us, like a notice of commencement and those types of things. So typically one of those partners in the trust, in the venture, will become the director of the trust. Now, the collateral assignment is what I really want to talk to you. The biggest advantage of lending to a borrower who's purchasing in a trust or has already placed their property into trust is the fact that you can get a collateral assignment of beneficial interest. Now, what is that? A collateral assignment is when the beneficiary borrower, at the time they borrow and that note and that mortgage is signed by the trustee and the personal guarantee is signed by them, they also sign an additional collateral of assignment document. And that says that they are assigning you the collateral in that property. They're assigning you the benefit, the right to be the owner of that property, basically. But it's only to be exercised upon default. But the important part is that the trustee, everyone signs it at that time, and the original document for us sits in our file. So if at some point the note and mortgage, if there's a default, typically the note is an exhibit, or it's going to be in our file as well. There's a default on that, then they're going to, obviously the lender's first going to reach out to the borrower and see what's going on, give them a time to cure, remind them of those dates in the mortgage, their time to cure their default. If it's not cured, they're going to call us and they're going to say, we want that collateral assignment that's already been accepted by you as trustee. We want that placed into effect. We want a new management agreement. We're going to take over that property and see, we're going to make sure we can either sell it or collect rents or whatever in order to keep our loan secure. So that is very important. And it's something that I have a lot of lenders. When hard money lender, he only, he only lends to people who are placing their property into trust at the time of the loan if they haven't already. And this document is one of the key pieces that he uses. Now there's also protections for the borrower. The borrower, obviously their credit is going to stay clear of multiple encumbrances. When you're building your rental portfolio, you don't want to necessarily pay cash for every rental, or you won't have enough cash to keep building that portfolio. You're going to want to leverage some of those properties. So after about 3 or 4 or 5 mortgages on your credit, you're going to be hard pressed to find a bank that's going to keep loaning you traditional funds. So you're going to have to go to probably a private lender or a hard money lender. And at that point, if those properties are in trust, then the trustee is going to be signing, and you're not going to keep having, 10, 12 mortgages on your credit. And that's also important because as you grow your business and, you've got like 20, 30 rental properties now, and you're doing well with your cash flow, you may maybe you want to upgrade your own personal residence. And you go to the bank to get that, 4% loan on your personal home, and they say, oh, you have like 12 mortgages out there. You're like, yeah, but I only owe like 20 or 30 grand on each, and I have a great LTV, and they don't care. They don't want to hear that. So keeping your credit clear of multiple encumbrances is important. The privacy is the trustee signing the note and mortgage. The lender assets. Now this is important for lenders too. Not a lot, but several of our clients are using lender trust now. That can be very important for you with NewView accounts. When you're lending, you don't necessarily want there to be multiple mortgages out there in the name of your NewView account, showing that, hey, this person has a lot of assets through mortgages. They must have a lot of assets in their personal life as well. So remember, the whole goal with using land trust is to keep that privacy. So we have a few deals in our office where the borrower has placed the property in trust, and the lender is also loaning from a trust. It also makes it nice when there's a lender trust and there's several people, there may be several beneficiaries of that lender trust. Say it's a $180,000 loan and somebody's bringing 50 and another person's bringing 35. And so you can do all that instead of it being sort of out there on the mortgage that all of these people have an interest. So it's much cleaner and much more private. That's the ease and privacy of partnerships. Obtaining insurance. This is always a very popular question that I get is, how should the insurance be named? Because a lot of times, especially when you're doing a subject to, there's already insurance in place, but it's insuring someone else. And now the title ownership of the property is changing. So the insurance needs to run with the deed. So it needs to be titled in the name of the owner. So it would be Commonwealth Trust Services as trustee of the 123 Main Street Land Trust. Now, in a subject to situation, the mortgage person, the mortgagor, right, he's still on the mortgage. So you want to make sure they're an additional insured. If they're not an additional insured, that's going to be a flag to the bank that why is this borrower, owner of this home, no longer on this? So they'd want to be an additional insured. A lender may be an additional insured. The beneficiary doesn't have to be an additional insured. They are just a party in interest, because with us as a corporate trustee, we have a trust account, and any insurance proceeds that would be getting written and sent to our office, because that's the address that's going to be on public record and the insurance is going to have. So we get the insurance check, it goes in our trust account, and it gets written out to the beneficiaries. I like to bring up lease options. I think I said in the beginning that a land trust can hold any property interest. And Blake also touched on it with his little diagram, that it can hold notes and mortgages. It can hold, obviously, real property. It can also hold leases, because that's a property interest. It can hold an option agreement. So the trustee can actually sign the notice of option, and that can be what's on public record. So if you have, if that's the way you're purchasing properties, is through options, you have several options going on at the same time. Maybe you don't want the person you're dealing with as the seller to know that. They wouldn't be able to search your name and find that out. It becomes really important too when you are a landlord. You have your property in trust, and you're either managing it under your LLC, or perhaps you have a third-party manager. So with a lease option, you want to make sure that the lease agreement is totally separate from the option agreement. You have a lease under which standard terms that the tenant would be evicted. That's not going to change. And then you have another agreement, which is the option agreement. Now, the lease agreement is going to be signed by the manager. Trustee doesn't need to sign that. The management company signs that. But the the option agreement is going to be signed by the owner. The court grants more rights to a purchaser with a normal lease option than a mere tenant. And what that means is we run into a lot of investors or landlords that, they do a lease option. They have it all in one. They have their lease, and then they give the tenant the option to purchase it. And then the tenant's paying under those circumstances. Then they go to a victim, and the judge says, well, this kind of looks like seller financing. You've given him extra rights. It's not just a standard eviction. So when the trust is the title owner, it's just a lot better. It helps you keep those things totally separate, because the trustee is going to be signing that option agreement to sell. They're the only ones that can, because they're the title owner. Then you've got a separate lease agreement with the management company. So using a land trust, the purchaser can be giving a lease that clearly allows for tenant eviction, but also has a contract for option for the beneficial interest of the trust in a separate document. Now, I just recently spoke on some seller financing, and I wanted to go ahead and touch on that a little bit today, just because I know there's a lot of people that if you have New View accounts, you're not lending currently, you're just trying to build those up, maybe through having your rentals, through doing fix and flips. Eventually, your goal is going to be wanting to be the lender, because that's less work. I mean, yes, it's still work. You have to keep track of everything, but you're not out there actually, managing projects and dealing with tenants. So you want to make sure that you know your borrower when you're lending. After all, you've worked really hard all your life to get these funds in these retirement accounts. And when you're going to start lending from them, you want to make sure that your funds are safe. So you want to determine if the borrower is experienced. If they're not experienced, are they going to be partnering with someone who is? So those are the kind of things that you want to talk to your borrower about. Or if they're not experienced, are you only lending them 10% of the project? And that makes you feel a lot better, and they're using their cash for the other part. You want to be able to check their credit history, and how are they taking title? That is very important. You don't want to lend to investors that are taking title in their own name. Sometimes circumstances change in somebody's life, and a project that they're working on may become their primary residence. You're going to have a lot harder time foreclosing on them when it's their primary residence. And even when that property is in trust. Now, the good thing about having the investors place it in trust is when they do, a property in trust has a different characterization. It's actually characterized as personal property and not real property. Personal property cannot be homesteaded. Now, we do have clients that homestead their properties in trust, but typically they tell us that at the outset, so we do the paperwork a little bit different to reserve their right to do that. and then the deed indicates it's going to be homestead property or that it's remaining as real property. So having them place it in trust does add a level of protection there, but if they move into it and you take all those documents to the court might still say, yeah, but they're living there, it's their home, it's their primary residence, you're going to have to foreclose on them. But if they take it in their LLC or their corporation name, then they're not going to get those same benefits. Or if they have it in a land trust, then you're going to be, like I just said, you're going to be much more protected. Also, will the borrower sign a personal guarantee? And if they won't, you have to wonder why. And if they will, do they have, what is their structure personally? Are they, leveraged up to the hilt? They really don't have anything anyway. So those are the kinds of conversations you would want to have with your borrower when you're talking about loaning to them. And you want to investigate the collateral, comparable home sales. Are they purchasing all of the money for a purchase and renovation of a flip? If they are, then you might want to reach out to whatever realtors you know and have them send you some comparables so that you can compare that against the houses that the borrower is showing you. So you want to make sure that this property can support the loan. If you had to sell that house to another investor, is there going to be equity there to do that? Exit strategy. What is the borrower's exit strategy? Are they going to flip this? Is it a long-term hold? How much of your funds are going to be out for how long? Those are some things you need to know. Are there going to be repairs needed on this? Is it a rental property and then they're purchasing the entire amount from you to purchase it, or they're borrowing the entire amount to purchase it? How are they paying for any repairs that are going to be needed? Do they have the money to do that? How soon are they going to be able to get tenants in there? So all of those things are things you need to think about. If there's not enough equity in the property that they're purchasing, or you don't feel comfortable with the loan to value ratio, do they have a free and clear property that they can add to the mix as additional collateral? Also, what will be your position in this lien that you have against their property for the money that you're loaning? Are you going to be first? That's always the best position to be in. Now, being second is good. A lot of times we have a lot of clients that do second loans and are in second position, but they make sure that if that property had to be taken over, is there going to be enough if it's sold to also satisfy them after the first is satisfied? Now that becomes really important in a subject to scenario, because you want to make sure if you're loaning to someone to do the repairs on a property that they're taking over subject to, and for some reason that mortgage gets called due or the first mortgage goes into default, is there going to be enough there when it goes all the way to sale to protect your loan amount? So you've got to make sure that those things are in place. Third, nobody really wants to be in third position. I wouldn't recommend that unless you're part of the deal and you have control over the deal. So considering a trustee, obviously, you're going to want to be trustworthy. That's inherent. Now, for a land trust trustee, do they have the knowledge of the land trust operation and the legal issues that can come up? Use of discretion and adherence to fiduciary responsibility. Can they meet all of your needs? As a corporate trustee, of course, we're always available to sign things when you need them signed. We understand, myself as an attorney, and Augie Bylot as my partner in the trust company is a longtime investor, over 500 to 600 deals. So we have the knowledge to back up what we're talking to our clients about with regard to land trusts, how they work and how they protect you. And we also, when somebody calls on the property and they want to know who the owner is, how can I reach the owner? Is your Aunt Millie, who's the trustee, going to know what to say? Is she going to have the legal expertise to handle things that pop up? And if she's on her cruise, who's going to sign the sale document that comes in for you? So those are the things that you need to consider. With us, we provide all the document preparation, all the documents for your land trust. I also, as an attorney, assist a lot of borrowers and lenders with their financing documents. We do closing coordination. So when you purchase a property in trust with us or you're selling it, you're not going to have to sign any of the documents except the trust documents, which you can do either at our office or sometime during the closing. But we're going to be coordinating with the closing company. As soon as you send that contract to us, then we pick it up and we're the ones that deal with that, and we email you for anything necessary. We record documents. I think I already mentioned that we, if you're placing your own property into trust, or say you've already got a property in trust and you're getting a lender involved and some things need to be recorded, then we handle that. We also, of course, accept all mail and calls. We email you immediately with regard to those. Acceptance of process of service. Who wants to be served at their business or at their home? I don't think anybody. When your property's in trust, we're going to be getting that service of process, and we're going to be sending that out to you immediately. So lenders and borrowers sleep soundly when they hold their properties in trust and when they loan to properties that are held in trust. And that's us, yourlandtrust.com. You can find out about us there. Our next event is going to be as a sponsor of the Financial Freedom Summit, which is May 10, 11, and 12. That's going to be out 9th, 10th, and 11th. Thank you. So you can find out more about that at investorprofitsecrets.com or creatingwealthusa.com. So that's going to be our next event. You can always email me or look at our website and email us through the website. You can always call us at 407-755-1010. You can also call us at that number. That's also the number that we use for Creating Wealth as well, or that I'll use for Creating Wealth, and you can register for the next event there. We also do land trust seminars at our office too, about once a quarter. So does anybody have any questions? I know I'm leaving about 2 minutes for questions. Sorry about that. Yes.
Andrea, you were talking about earlier about collateral assignment of beneficial interest.
Yes.
Is that basically to avoid a foreclosure?
Yes, exactly. Yeah, and that's why I was trying to get across the fact that that only works with investor-held properties. We have had individuals loan on to, people that are going to live in those properties. Typically, they're not investors. We will put one in place and talk to the owner about it. But if they ever pushed back and they, fought the foreclosure, or fought getting ousted because the lender basically wanted to take over the property, then you'd have to foreclose. Go through the process.
You have a question online. Somebody asked the cost.
Okay. Yes, it is $550 to place your property into trust with us. That includes all the document preparation. Also includes your first year of trustee services, which after that, it's $100 a year for us to serve as the public face of your property, the trustee. After your first property, every other property held by the same entity. Some people have multiple entities and multiple beneficiary structures, but say you have an LLC right now that holds 5 of your rental properties and you want to slowly be placing those into trust, you're going to have a multiple trust discount for each additional property at $100 per trust. Now, some of the additional documents I've talked about, the assignment of beneficial interest, the collateral assignment, those are going to be additional costs.
You have another question online.
Okay.
When writing a real estate contract, do you write it in the name of an anticipated land trust before the trust is created?
Yes. Yes, you would go ahead. The question is, I don't know if they can hear you back there, but when you're writing the contract, can you write the contract in the name of the trust before the trust is created? Yes, you can. You can write it in the name of the trust. If you send the contract to us, we can go ahead and sign that upon you're going to be obviously placing in an order for the trust at that time, because the documents will be signed at the time of closing. Sometimes our beneficiaries do come in, our clients do come in a day or so before closing and sign the documents, but we can go ahead and purchase it with the name of the trust prior to that happening.
So in the back end, when you sell a property that's in the trust, does the sales contract also come to Commonwealth and the trust?
Yes.
For those to be
yes.
signed. So I would never have to sign anything myself.
Right. So the question is when properties are sold out of trust, does Commonwealth, if we are the title owner as trustee, do we need to sign them? And yes, we do. It actually wouldn't be a valid contract unless the owner of record is signing it. A lot of times what clients will do is they'll initial every page. They'll send it to us so we can see that they've approved it. Of course, it comes with an email. Then we sign that, typically get that turned around in an hour or two, unless it's a weekend. Then they'll text us or something. So yeah, we do that.
The one thing, though, that the beneficiary will sign is a letter of direction, okay? Because we do not do anything without your authority, okay? And that's a really important difference, you know, when you're working with a corporate trustee. But we only do things when we receive written direction from the beneficiary. That's, you know, one of the statutory protections that a beneficiary receives through the statutes here in Florida.
That's right, written
It's a very
direction.
simple form. You can, you know, we have a form that gives you lots of latitude for telling us what to do. And many times it's just check this box, or that box, because they're already standard things we do. You know, sign a closing package, you know, sign a notice of commencement or whatever it might be. And it works real well. And there's also space. If you have a customized kind of request, you can just kind of write it in, sign it, and get it done.
It's also in Word on our website. So,
I'm not sure, can you read that?
no.
Is it too small?
Oh, wait. I know, I typically can't.
Okay, they asked in the case of a contract written in the name of the trust, do you pay the $550 trust service fee at time of contract?
Okay, so.
What happens if the offer is not accepted or does not close?
Okay, so the fee is not paid at the time you contract. If you go ahead and contract in that trust and then you find in the name of the trust and you find out in 24, 48 hours that it's not going to, you know, go through, then obviously there's not going to be any charge for that. Our first-time clients will go to our website to order their trust and their first trust and pay a deposit. After obviously we're building relationships with our clients, we understand how you do business, then they're not even going to have to typically pay a deposit when they order that trust. And usually they won't order the trust until it gets through that 5 or 7 day inspection period, because they might not be going forward with it. And unless it's like under a 2-week close, typically it's not, because they have to get some title work done. So with that in mind, you know, the title work done being 21 days out, and then they're going to go ahead and have a 5 or 10 day inspection, that's when they send us the order. And we start communicating with the title company, we get the paperwork done. And as long as we have the paperwork to the title company by about 3 or 4 or 5 days at the earliest before, then we're all set for closing. Is that it? All right, great. Well, thank you very much. I think Blake's coming back up.